Assalamualaikum. We are from Group W, and our topic for today is the principle of non-intervention in international law, the relationship between state jurisdiction and territorial sovereignty. I am Nur Najat Minti Baharudin, and together with me are my friends Nuranisha, Zahirul Azmir, and Nurul Atira. For today's topic, we are going to discuss on history of principle of non-intervention and modern interpretation of principle of non-intervention, type of intervention, the law of intervention in state jurisdiction, intervention in state jurisdiction and territorial sovereignty, and the fifth one would be cases on intervention and doctrine of extraterritorial jurisdiction.
For the introduction, we're going to touch about the intervention and sovereignty, which is the concept of non-intervention follow international jurisprudence of tradition, stipulating that a nation must not participate either directly or indirectly in the other nation's domestic affair. An international of solidarity and interconnectedness that has diminished domestic jurisdiction horizons and expanded international jurisdiction horizons are resulted from globalization. The state lies on the basis of sovereignty, which reflects the superiority of government bodies internally and the supremacy of the state as a legal citizen externally. Territorial sovereignty usually indicates a political and legal term in referring to a relationship of a sovereign supremacy or power between the territory of an actor, the state, and entity. Sovereign itself is established on the basis of the land with its preservation of legal rights and duties in which a lawful individual cannot be a state without territory. Fundamental legal principles such as jurisdiction and sovereignty can only be interpreted with regard to the borders. Thus, in every study of international law, the territorial legal existence becomes an integral aspect. Move on to the next slide.
Today, I will be discussing the history of principle of non-intervention and the modern interpretation of principle of non-intervention. The principle of non-intervention formulated in 1785 by Bettel, and this principle has been implemented in the Constitution of France, which later amended by them, which mentioned that French is allowed if it's reasonable to do so in terms of intervening other states' domestic affair. Intervening the domestic affair used to be considered as one of the method of dispute settlement since before the formulation of this principle. The earliest treaty mentioned in regards to the principle of non-intervention is in Article 15, Clause 8 of the Covenant of League of Nations and Montevideo Convention on Right and Duties of State, 1933. In modern interpretation of principle of non-intervention, which are divided into three matters, which are the efforts made by the United Nations, International Law Commission, and International Court of Justice. The principle of non-intervention has been laid down by the United Nations in Article 2, 4, and Article 2, Clause 7 of the UN Charter on the clear prohibition of the threat or use of force on members due to the respect of the sovereignty, territorial integrity, and the independence of political matters. The establishment of UNGA also which clarified that the state shall refrain from any threat whether it is directly or indirectly to impair the freedom of the state. In the International Law of Commissions, in Article 3 of the Draft Declaration on Rights and Duties of State 1949, it mentioned that the duty to refrain themselves from intervening, whether it is external or internal affairs, is the duty of state. In the Charter of Economic Rights and Duties of 1974, it mentioned that economic matters shall be governed upon many principles and the principle of non-intervention are part of it. The prohibition of it is also clear in the Declaration of the Inadmissibility of Intervention and Interference in the Internal Affairs of State 1981. On behalf of the International Court of Justice, the principle of non-intervention has been laid down in the Corfu Channel case 1949, ICJ Rep 35, which mentioned that the principle of intervention has been abused in the past and cannot be upheld in international law. Meanwhile, in the Nicaragua case, the principle of non-intervention is by recognizing the right of sovereign state to handle their own affairs without outside force. The principle of non-intervention is a compelling law and it is part of customary international law.
So there is two types of intervention, which is direct intervention and indirect intervention. So for the first one, direct intervention is military involvement or forced invasion or dictatorship based on standard international law. Only this may take the formation of military control, restriction, protest, barricade, another state property detainment, or foreign national removal. The term intervention is also used to refer to actions involving the use of force, known as forceful intervention, which is humanitarian intervention. Next is foreign military intervention is the invasion of one's region's army or power into another country's land or water territories or political issue or conflicts and armed forces are deployed in other countries. And lastly is the important issue of forceful action is that separate legal limitation extending to the use of violence such as interference on invitational basis. And then the next one is indirect intervention, which is the enhancements of collaboration between nations has made it possible for state to interference indirectly without any force regarding domestic affairs of a state. So there are three types of indirect intervention, which is subversive, economic, and diplomatic interference. So for the first one is subversive interference, which is any intervention carried out by one state is to influence or indirectly to control the situation in another state. And then the next thing is economic intervention, which is by imposing penalties, blockades, and embargo in the trade industry, which leads to denying the access pass to the land and water. And lastly is diplomatic interference, which is generally it did not constitute unlawful interference, but may be treated as prohibited action if they include.
So then we move on to the next chapter, which is the law of intervention in state jurisdiction and territorial sovereignty, which is first of all, according to Anthony Papiti in his article on intervention in the internal affairs of state, military force and violation of territorial sovereignty can be made permissible in compliance of the terms stipulated in the UN Charter. However, we shall have a look first on the provision of Article 2, Subsection 7 of UN Charter, as my friend mentioned just now, which clearly prohibit any intervention to be made upon any state. So we can conclude that any intervention made by UN or its members cannot be done, as it would defeat and contradict the doctrine of territorial sovereignty and the state jurisdiction acquiesced by every civilized state. However, there are exceptions allowing such intervention as enumerated under Article 1, Subsection 1 UN Charter, which is on the ground of maintaining international peace and security. So this proviso could be the turning point of the statement made by the experts, Anthony Papiti, just now. Maybe at the first place, the intervention was illegal one, but in order to uphold peace, it is allowed under the principle of international law.
Under UN Charter, two entities were allowed to make intervention, namely the state and United Nations. So under United Nations, intervention by United Nations can be seen in Article 39 of Chapter 7, and grounds of intervention were divided into three, which are collective intervention on humanitarian ground, on the ground of civil war, and ground of environment catastrophes. Next. On humanitarian ground, human rights law has a vital role in international law. War is the last resort for remedy concerning human rights violation when it involves serious cases of human rights deprivation. A renowned jurist stated that the use of threat or military force must be proportionate to the danger, and it can be seen in the case of Iraq treatment of the Kurds. Next. For ground of civil war, according to Article 2, Clause 7, the UN cannot intervene in any affair of a state. However, if civil war was affecting the peace and security pursuant to the international law, intervention can be made. However, it must follow the procedure in Article 39 of the UN Charter, and this can be seen in the case that happened in Congo. For catastrophes, until today, the United Nations Security Council has not made any collective action based on environmental issue. However, it was expected by some jurists that environment catastrophes may cause collective intervention in the future, and it can be seen in World War II, where before World War II has taken place, the violation of individual and absence of organization structure were not considered as a threat to peace. However, it all changed after World War II. And the intervention can be seen in Somalia conflict 1992. Next. So intervention by a state can be explained regarding the self-defense, of which is the exception in Article 2, Clause 4 of the UN Charter, and it was divided into four, which are intervention on ground of self-defense, right of anticipatory, intervention to eliminate existing government in a state, and lastly, doctrine of extraterritorial jurisdiction. Next. For ground of self-defense, it can be seen in Article 51, where the affected state can apply the use of force against the wrongdoer states on the ground of self-defense. The ground of self-defense was believed to exist a long time ago. In self-defense, the principle of proportionality, which involve limitation of means and limitation of time, need to be considered. Next. So for the right of anticipatory, the concept of anticipatory self-defense is important as modern weapons tends to be more advanced. The weapons are able to launch an attack with a high speed, which may cause the targeted state not having enough time to react to that. Thus, the anticipatory self-defense is required as a precautionary step in protecting the country, and it can be seen in the case that happened in Cuban Missile Crisis 1962. So moving on to eliminating existing government in a state, it applied the Bush Doctrine, where Bush Doctrine has declared that America could launch the first strikes towards the terrorists and the countries that supporting the terrorists in order to prevent any upcoming attack. So the doctrine was adopted as a response towards terrorist attack known as the United States War Against Al-Qaeda. The coalition between United States and Great Britain, however, was not justified as self-defense because no assault has been made by Iraqi government. The next. For doctrine of extraterritorial jurisdiction, it can be defined as an application involving the regulation of conduct beyond states' border. This doctrine will be in contradiction with general principle of international law, which the state only can exercise its jurisdiction, not render any domestic can only apply its jurisdiction on a territorial basis. However, there is an exception in which if the original state does not render any domestic jurisdiction upon the situation disputed in the states. The court stated that every transaction has their foreign elements that represent the application of extraterritorial to United States law. Oh.
Okay, so after we had a long discussion on the intervention on by state or UN, there is one issue that arises, which is pertaining to intervention by invitation. So, according to Petra Petricic, any military intervention involved with prior consent from the host state are deemed acceptable to be applied, provided that certain conditions allowing such intervention satisfied at the first place. This practice can be illustrated on the basis of state practice and international legal doctrine. So, in general, intervention by invitation, or widely known as consensual intervention, has been defined by International Law Institute as a type of direct interference by the intervening state in the form of military assistance involving the sending of armed force to the host states upon request. This type of intervention did receive a heavy criticism from the experts, as they allege that it is a mere method to uphold what is not allowed under the law, and this can be this allegation has been made in reference to the case of French intervention in Mali and United States drone strike in Pakistan. However, a liberal approach has been promoted in one of the cases, which is Nicaragua against United States of America. In this case, the military and paramilitary activities occurs in and against the state of Nicaragua. This is a quite controversial case, as the court agreed that it is on the state to decide freely, on which there is no deprivation on the principle of state sovereignty. And it shall be noted that wrongful intervention only takes place upon the establishment of element of coercion. In further strengthening the verdict of the case, the court said that this decision was made in line with Article 20 ILLC draft, Articles on Responsibility of State for Internationally Wrongful Act, which provide that valid consent by a state to the commission of act by another state shall preclude the wrongfulness of the act done by the latter state, provided that the act committed shall remain within the limits set up upon that consent. So, finally, other related cases pertaining to this topic is firstly pertaining to doctrine of extraterritoriality. One of the cases that can be referred to is North Atlantic fisheries case. And briefly, this case is about a claim on the sea territory and intervention in fishing vessels by Norway. And this claim has been challenged by the state of UK, and this challenge has been proceed to the International Court of Justice. And in this case, finally, the court allows such claim made by Norway and further clarified that the waters to be part of Norway territory in accordance with the principle of international law. Next case is the NATO intervention in Kosovo, which is this case is concerned about intervention by state. This case, an issue arises whether the action taken and its method by NATO is just due to the fact that it's caused mass killing of the refugees rather than stopping the cruel regime. So at the end, the commission held that NATO intervention was illegal, but a legitimate one, as this intervention succeeded in stopping the cruel regime, but the intervention made without prior approval from the UN Security Council. So such intervention is allowed by the ICJ.
In conclusion, the principle of non-intervention has existed since before, but the absolute nature of it cannot be applied due to globalization. The United Nations strictly forbids such intervention based on Article 2 and Article 2.7 of the UN Charter. Discussing this matter in 21st century, the legitimacy of a unilateral intervention is important due to the change of international law. The use of international law has particularly increased and the implementation of domestic law has decreased accordingly. Few suggestions were given in order to protect the peace and unity of the states is there shall be a comprehensive international law on the intervention, and secondly, domestic jurisdiction should be reviewed accordingly to suit the current national and international development. Last but not least, intervention that is based upon humanitarian ground should be put under a responsibility to protect and should not result as a right to intervene. The improvement in this area of law can help to change the perspective. Only when crisis has arisen. Thank you. That's all from us.